Mr. Bulletinman.
And today is the 13th day of February. It's actually Lincoln's birthday. I did not realize that. I went all the way to Hillsborough today, and I found out it was Lincoln's birthday, and the courthouse was closed. I was on a mission. I went to deliver the latest bulletin. Actually, I missed the actual courthouse complex even last month. I'm looking at the different, maybe perhaps a new car, but nonetheless. I wanted to just say hi to all my friends in Hillsborough. I got a couple, really, seriously, I got some friends in Hillsborough, believe it or not. It's amazing, isn't it? It's another miracle. The mere fact that Bulletinman is still alive after 16 years is a miracle, and the fact that I am now getting information from lawyers incriminating judges, and to the nth degree. I mean, my goodness gracious, this order I received, and this is Act 3 of the disorder in the court. I don't know how many acts this is in they're going to end up being, because it just keeps getting deeper and deeper. But I was able to drop off some bulletins in Hillsborough today to a few of the lawyers, and especially Miss Berg Newman. And really what this order is all about is it kind of lays out what my allegations were in the January bulletin, or maybe it was December, when I did the article about the scam. Folks, what a crime in America is provable personal injury, loss, or harm. Unfortunately, 80% of the court's business, and a vast majority of the court's business that it refers to Ms. Berg Newman, is simply not a crime. It is a crime indeed, but the perpetrators of the crime are the court and Ms. Berg Newman, and they are trampling over every civil right that you have. You know, our whole point and purpose of our government is to protect and maintain our God-given individual rights, and when it fails to do that, it has failed its chief design. And it's fair to say that our government has failed its chief design when it has the audacity to actually write an order of the court, basically admitting to perjuring his oath to the Constitution repeatedly. But not only that, and more importantly, you know, the oath of the Constitution really don't matter much nowadays, because we're under some sort of administrative law. Now, the government never told you about this, but we are under some sort of administrative, what I call maritime law. You'll notice the gold fringe around the flag. So the Constitution really doesn't matter much, and your Bill of Rights don't matter much. But what does matter to the syndicate that runs the court system in the state of Missouri and throughout the United States is when it breaks that their judges hold the judiciary to ill repute and disrespect. And typically they're able to sanitize a lot of that ill repute and disrespect because they police themselves. They have one guy who's got two secretaries and an investigator go out and investigate literally probably thousands of complaints about judges. Mr. Smith told me 300 or 400 a year or something crazy. One judge has only been impeached in the state of Missouri since 1960. Articles of impeachment were filed a couple weeks ago, but I understand they didn't go anywhere. But with what I have here in my hands and what I've been trying to go over with the last few days, we have, I mean, if there is no reason to impeach a judge in the state of Missouri, then, I mean, short of a judge actually going out and committing a capital crime, which I'm sure that happens, but they typically don't sit down and write about it. Other than that, Mr. Bouchard, and I hesitate to call him judge anymore because I really got to believe that he's not going to be a judge very much longer, has admitted in this order that he has violated just about everything you could violate. My goodness. And Miss Tammy Berg Newman seems to be his partner in crime in this whole matter. Folks, let's face it, the economy's in shambles. No one's got any money. Gas is $3.40 a gallon. They're imploding the economy on purpose, and we've got literally hundreds of people sitting in jail this afternoon. We've got thousands of people who are on ridiculous probations and basically slaves to the system. And if they don't pay Miss Berg Newman, if they don't take care of her, then she's going to run to the judge, and the judge is going to issue a warrant, and they're going to look into you any way they possibly can, violating all the canons of the Bar Association. But the most damning thing that this Mr. Bouchard did back in on this issue, and the case number, in case you're just catching this, is 09JECR 01761. I'll read that again. 09JECR01761. The defendant is a Joseph J. Schaefer, and the state of Missouri, of course, is the plaintiff. Miss Paris from the prosecuting attorney's office is handling the prosecution, and Mr. Schaefer has a public defender, God bless her, who's actually standing up to the tyranny that is happening right there in her own courthouse. And but I wanted to basically, the first act of this, I read most of the order. The second act, I pretty much just kind of like rambled on about a few other things. Didn't really talk about the order much. But this is Act 3, and I'm going to read the rest of the order. The most damaging allegation here is that when you have a hearing, if you're in typically an ex parte hearing is when you get in a fight with your wife. She runs to the courthouse and gets an order to usually kick the man out of the house with no legal remedy until they can actually get before a judge. But the reason why they have an ex parte hearing, a one-party hearing, is because the defendant cannot be summoned to the court at that time. Now, when you have someone in their custody, it's an entirely different matter. And I'm going to read this. Now, this all started back in November of 2009, November 18th of 2009, which, by the way, is my brother's birthday. My goodness gracious, isn't that crazy? All right, so this all started on November 18th of 2009. And, okay, now we're up to January 26th of 10. And Miss Berg-Newman has sent an email to the judge saying this man's going to go out and like slaughter half of the county because his mama says so. And remember, this all started over a driving while suspended, not even revoked. Okay, so this is where we're at with this. On January 26th, after indication that Mrs. Freeman, who is the heroic public defender, and Mrs. Perez, who is the prosecuting attorney, had come to an agreement upon disposition, each met with the court in chambers to discuss the disposition. The proposed disposition included a release of the defendant from custody on February 7th of 2011, without provision concerning residency. The court inquired of Miss Freeman whether she had seen the January 12th email report of Miss Berg-Newman. She said she did. The court then stated that it had significant concerns regarding the defendant's proposed release in light of the January 12, 2011 report. The court wished to hear from Ms. Berg-Newman personally before making a decision. Oh my goodness. Mrs. Freeman argued that Mrs. Berg-Newman's role in the case was limited. Most of the information in the January 12, 2011 report came from the defendant's mother, and that she was in the court. The court then stated that it wishes to speak with Mr. Schaefer after the courtroom had emptied. Okay. Hallelujah. Hallelujah. So they want the courtroom to empty before they can talk to him. When the court called the case, Ms. Freeman requested that the defendant be brought down from the holdover to hear the statement of his mother, citing the defendant's right to confirmation. Part of the Bill of Rights and the articles of in the state of the Bill of Rights and the Constitution of the United States and the state of Missouri is that if you're being accused of a crime, you have a right to confront that accuser. Now, actually, he is actually being accused of a crime at this time because he's actually not even being accused. I guess there's a potential that he could go out and harm people. And again, I can watch Act 1 of this to get the full story. But now, so the court stated, okay, Miss Freeman objected to this. Okay, so let's go back up here. Well, let's see here. When the court called the case, Miss Freeman requested the defendants be brought down from the holdover to hear the statements of his mother, citing the defendant's right to confrontation. The court inquired of Miss Schaefer whether she could speak in candor with her son present. She indicated that she would have difficulty in doing so. The court stated that it was not inclined to bring the defendant into court, as if wanted Miss Schaefer to feel comfortable about making frank statements about her son. Miss Freeman again objected, arguing that the defendant had the right to hear any statements his mother made. The court stated, never mind the oath I took, never mind my responsibility to the Bar Association and my handlers, never mind every 400 years of American and Western jurisprudence. Never mind all that. The court stated that while it did not wish to violate the defendant's right to confrontation, it did not believe the defendant needed to be present because the court was not using the information as a basis for revocation. Okay, so if the court is not using the information as a basis for revocation, and they're talking about letting the kid out, what is the court using the information for? The court's concern, okay, Bouchard covers this. Bouchard covers this, and let me read here. But rather to determine whether the defendant could be released from custody. In Ms. Freeman's statements of fact, she stated the court said the information would be used only as a basis for modifying its probation. This is not the court's recollection. The court's concern at this time was definitely focused on whether the defendant could be released from custody in accordance with the agreement reached between the counsel. Ms. Freeman is the public defender. She called the judge on all this, okay, and the court said, oh, I can't remember. Because the court at one time had told Ms. Freeman, the heroic prosecuting defense attorney, public defender, and you talk about the whole public defender system in the state of Missouri. These people are underpaid, overworked, but this woman actually fought for her client. Okay, so the court suggested. Okay, the court's concern at this time was definitely focused on whether the defendant could be released from custody in accordance with the agreement reached between counsel. The court suggested the case could be set for a formal revocation hearing at a time when the defendant would be present. Ms. Freeman stated that she did not wish that case be set for revocation. The court's recollection is that Ms. Freeman then agreed to proceed. Ms. Schaefer sat in front of the jury box. She was not placed under oath. So she wasn't even placed under oath. She's given testimony to the court, and she's not even placed under oath. Oh, my goodness gracious. She answered questions posed by the court. Neither counsel for the defense nor state questioned Mrs. Schaefer. So the judge is asking questions. I thought a judge was a referee, not an actual determiner, like a prosecutor. At the conclusion of the proceedings, the counsel again met with the court in chambers. At this time, the state announced that the parties had reached agreement with any release of the defendant would be directly related into inpatient treatment provided by Miss Berg-Newman. Maybe that's what the judge wanted to see Tammy Berg-Newman about. Hey, Tammy, I'll make this man pay some money. What's in it for me, huh? Yeah, you wouldn't want to think that happens. But it certainly appears it does, doesn't it? Ms. Freeman, the public defender, did express displeasure with the defendant's continued confinement on driving while suspended case while the allegations of probation violations were drug and property offenses. A condition of the defendant's probation is, though, to obey all law. The court did advise Ms. Freeman they were now dealing with a drug case and it would be treated as such. Okay, was he charged with drugs? I don't think he was ever charged with drugs. But the court said, Mr. Bouchard said that they're now dealing with a drug case. Conditions of the release of the probation revocation proceedings involving allegations of drug use coupled with the allegations of recent property offenses are considerably different from those that the issue had defendants merely picked up on a new traffic offense. The court cannot be expected to put binders and disregard allegations of probation violations because the underlying criminal case differs from the alleged probation violations. The case was continued until February 3rd of 2011 to allow Ms. Freeman an opportunity to arrange for inpatient treatment. Ms. Freeman filed her motion for recusal on February 2nd of 2011. At the time of the January 26th hearing, the court believed as the information to be elicited from Ms. Schaefer was limited to the issue of whether the defendant should be released from custody as proposed by the parties, and the defendant was to be released. Conditions are the same since the defendant was represented by counsel, who the court understood to have agreed to proceed. The defendant's presence would not be required. In retrospect, in retrospect, Steve, the best approach to the January 26th hearing would have been for the court to order the defendant's presence His liberty was at stake insofar as much as information provided by his mother was to be used by the court in determining whether he would be released. As his liberty was at stake, his presence should have been directed by the court. He even admits his own mistake. Well, God bless you, Steve, for owning up to the fact that you made a big mistake. The court is not prejudiced against it, nor has it prejudged the defendants. The court, while acknowledging likely error in not directing the defendant's presence at the January 26th hearing, does not believe that such nor any other allegation in the defendant's motions require that the court recuse itself from these proceedings. Ms. Freeman argued otherwise, obviously. The court has thus decided to avoid any arguments that there is any appearance of impropriety in these proceedings on its own motion, for this reason alone, to recuse itself from further proceedings. And the case is went into the Dick Hayner's hands, and I will tell you about that the next time. Folks, serious trouble in the court. Judge Bouchard was caught. And how many aren't caught? How many other public defenders don't go to bat for their clients? And just how far down the rabbit hole do we have to go, huh? I love you, and as always, I ask you to tell a friend about me. I'm the one and only Bulletinman. I see exactly what my time is on this. Oh, my goodness, 16:21. For God has not given us a spirit of fear, but power, love, and a sound mind. Oh, and I don't know where the other one went. Well, Google Fiat Empire, you realize the money we're all fighting over is just paper. And the website is kjeff.com. Of course, you can't see that. I do love you, and I do appreciate you tuning in. And as always, I ask you to tell a friend about the one and only Bulletinman. We'll do Act 4 of the disorder in the court next couple days. I did make it to Hillsborough today, but it's Lincoln's birthday. Ain't no one in Hillsborough. None of the people at the courthouse were there. I went through the snow, but I love you all. I really do. And that's why I'm doing this, man, is to save your life. Because your life is in jeopardy because of people like Stephen Bouchard and Tammy Bergnew who are out extorting the people. And you know what? Some people just can't take it. Some people aren't saved, born again, filled with the Holy Ghost, on fire for Jesus. Are you? See ya.